A very good afternoon to all. Myself Needu Krishna, second year MSc Computer Science student, once again wholeheartedly welcome you all to this session. First of all, let me take you through our journey so far on the 5-day international webinar conducted by Department of Computer Science. We explored powerhouse for innovation and economic growth on the first day, IPR in the present of competition law on the second day, building IPR portfolio in the startup ecosystem on the third day, and IPR and innovation on the previous day. Patent analytics is a growing field that encompasses the analysis of patent data, analysis of the scientific literature, data cleaning, text mining, machine learning, and data visualization. So today, we are going to know more about patent analytics as a research and business tool. Now, I invite Dr. C.S. Piju, Associate Professor, Department of English, and Director of Center for Performance Research and Cultural Studies in South Asia, to introduce today's resource person, Dr. P. Lakshmi Santhi, Senior Manager, Client Relation, SciTech Patent Art Services, Hyderabad. Over to you, sir.
Thank you, Ms. Needu. Good afternoon to one and all. Here we have the convener of the program, Dr. Jiju, the coordinator of this webinar, Ms. Ramila ma'am, and today's resource person, Dr.P. Lakshmi Santhi, with us. This is obviously a great privilege to be a part of this wonderful program, which today we have the last session of the webinar. One of the most significant factors regarding this particular area of intellectual property is that a program on intellectual property is that intellectual property has become one of the seminal, phenomenal practices in academia and in the world of technology and science. Even in philosophy, IP has become a phenomenal issue. So the importance of this particular program with 4 sessions is that it has started a wonderful deliberation on the pertinent questions connected to intellectual property. Today we have an amazing resource person, Dr. P. Lakshmi Santhi, who is serving as a senior manager of customer relations in SciTech Patent Art Services. And one of the spectacular features of her career is that she is a qualified Indian patent agent. More spectacular is Dr. Lakshmi has a PhD in chemistry, and she specializes in catalysis. And she has a wonderful 10 years of research experience. And she has expertise in state-of-the-art searches, novelty, patentability assessments, freedom to operate, right to use, and validity searches among a range of IP activities. And she specializes in novelty, patentability assessments, and from this to claim charting, patent product linkage, patent watch, patent drafting, and so many other areas too. Her session today focuses mainly on IP as an innovation and the complex web of intellectual property as an innovation leads her vision into IP innovation as a seminal phenomenon in global economy. And gradually, subsequently, she brings home the idea of innovation and its immense connections with patent analytics. And it elaborates upon, her session elaborates upon the role of patent analytics and the significance of IP in today's global economy, academia, and all sorts of human activities. So we are the Department of Computer Science, St. Thomas College, and our institution, St. Thomas College Autonomous, are immensely happy to welcome Dr. P. Lakshmi Santhi, today's resource person. A wonderful welcome evening, and welcome, ma'am. Most welcome to the session. Over to you, ma'am.
Thank you so much, Dr. Biju, for introducing me. And first, I would like to thank the organizers for providing this opportunity to share my thoughts and perspectives with respect to how patents can help, patent studies can help a company or an organization, be it an academic institute or any startup, to enhance their technical expertise and leverage the potential outside their organization as well. And before I can actually dwell deeper into the intricacies and various other aspects, I thought I'll first start off by answering to the frequently asked question. Most of them, whenever I keep speaking on various platforms, people have a common question. You have 10 years of research activity in the field of chemistry. How come you have ended up in an IP sector, a patent sector? So basically, it all started from my own personal experience. When I was a researcher at ICT, as a PhD student, and within our team, we developed a particular process, which was a catalytic process, and probably the first catalytic process which was very efficient for a person, for a particular reaction. Until then, probably there were only stoichiometric reactions. And basically, just like any other researcher, after completing my PhD, I wanted to pursue a postdoc fellow outside India, and I luckily had a fellowship request at Kyoto University, one of the prestigious institutes in the area of catalysis. And I was in a hurry to actually submit and get my PhD degree before I could proceed further. So in the process, what we did was we went ahead and published it in a journal. And when we published it in the journal, then finally we saw that after a few years, a Japanese company was using our technology for a bulk scale production. So there began the story of my journey into patents. That was an eye opener. We realized what loss in terms of revenue generation we had. It would have been a big achievement for us had we filed a patent. But unfortunately, we didn't do that. And moving forward, since then, we have been proceeding with, one second, let me just, yeah, I'll share my screen. Yeah. From there on, there was no looking back, and I had surged forward in the area of patent services. So, is my screen visible? Can someone confirm if my screen is visible?
Conducted by Department.
Visible? Can someone confirm?
It's not visible, ma'am.
Is it visible?
No, ma'am. You are visible. You are visible.
The screen is not yet visible. Can someone confirm?
It's not visible.
Is it visible right now?
No, ma'am. You are visible. You are visible. Yes. Now it's visible, ma'am.
Can someone confirm?
It's not visible. Yes.
Is it visible right now?
Now.
Okay,
No.
1 second.
You are visible. You are visible. Yes. Now it's visible.
Okay. I'll take it. Okay. So I'll proceed with my topic, the patent analytics as a research and business tool. So probably we were ignorant or whatsoever. We didn't realize the potential of our invention, nor did we actually probably understand the importance of filing a patent for the technology that we develop. So then we started drafting and filing more and more patents from our team. And that was when I got initiated into patents. And after completing my research tenure, then I moved on to the patent services firm, SciTech Patent Art Services. Initially, in the first 1 week, I was actually posing a question to myself if it were a right decision that I had made by moving from research to patent services. I used to always pose this question to myself. Then I realized that after that, I get an opportunity to work on a different technology almost every other day. We work on different technologies, different domains. A lot of learning is there. And what importance patents and patent analytics could be to corporates or any other researcher or firm. So then we started moving ahead. So first of all, you must be hearing about invention, innovation, patents, commercialization. These are all terminologies, jargon that we always get to hear a lot. Even probably during this webinar series, this has been the primary focus. So what do we mean by inventions or intellectual property? Whatever comes out of our intellect, that is creation of our mind. And so this creative work is called intellectual property. And this intellectual property has to be protected. Why is it to be protected? So that because we put in a lot of efforts, a lot of time, money, efforts into it. So definitely there should be something that should be returned to the creator, some benefit to the creator. So the intellectual property laws were introduced. These intellectual property laws provide certain exclusive rights to intellectual property owners. These rights could be positive rights or negative rights. What do we mean by positive rights? Positive rights means to make, use, or sell. That is, you have a monopoly for about a period of 20 years from the date of filing. If you are issued a patent after filing for a patent application, then you get protection for your technology. So until and unless they take protection, or you will not be able to protect your technology until you file a patent, get a patent. Once it is protected and you keep maintaining it, if someone wants to use your technology, they have to seek license or buy the technology. Now, why do we seek negative rights? What do we mean by negative rights? It's nothing negative, but it says that you're stopping others from making, using, or selling your technology, which is protected by a patent during the period of protection. So that is the basic crux of the protection. Earlier, people would invent, either they would openly present on seminars or any publish in a journal, whatsoever, or there were companies which would create technologies, inventions, innovations, and they would hold it to themselves. They would keep it confidential. One such instance is Coca-Cola. It's a great example for such innovations. They have a formulation which is not out there in the open. But doesn't it have a risk? Definitely. As long as the technology or the formulation is a secret, it is fine. But once it is in the open, can we stop someone? No, because it is not protected by any other means until there is some proven means that it was taken by or obtained by an illegal manner. So it is best to always seek protection for your invention. Then not only look at revenue generation, but also to see how you can contribute your technology to further development in the domain. So when you're innovating in this world where there is a constant need for better and better products and better processes or services, always there is an urgency for it. So how can we achieve this? You can either buy external IP, which means that suppose I need to market a product, there is a certain technology that a second party has, and I need it to incorporate in my product to make it beneficial or have advantage over existing products, then the best means will be for me to either buy or seek license from them. Another way is to, suppose I'm a researcher, I'm an academic person, and then someone else would want to use my technology. I can always sell my technology. I can just cite a quick example when I'm speaking about selling or licensing IP technology, etc. There's one particular client who happens to be a pediatric cardiologist. He has developed a cardiac device. Okay, as an expert, he has developed it. But where is the means and opportunity to develop the prototype? And then how to commercialize? Do they even commercialize by generating production units and all that? No. So they definitely had to tie up with a company. There is a company which came forward to him. They developed the prototype and then they had an agreement in place which helped him get the prototype, required amount of prototypes to try in patients. Then once it is successful, the trials are done, he has filed for a patent, it has been granted in certain countries, and then he has also signed an agreement with the company for further commercialization. Normally, when such commercialization takes place, there are two ways that it can be done. It can be either outright selling of the technology, or another way is that you have a royalty means or licensing for a certain period. So this is how you can always constantly look at developing new processes or products or protocols. All of you must be familiar with the various forms of intellectual property rights. The patents, designs, trademarks, copyrights, geographical indications, trade secrets, utility models, and traditional knowledge. These are some of the different forms of intellectual property rights. I will not dwell deep into all these, but I'll quickly walk you through a couple of examples to let you know what can be protected by which form of intellectual property. On the left-hand side, you can see a pressure cooker from Primavera. So the individual aspects, the individual components, the way it is assembled, the mechanistic aspects that are associated with this particular cooker, all this is protected by patents. Then the outer shape and configuration is protected by a design patent. Then Primavera, it is a brand name. The brand names and the logos, these are protected by trademarks, and the manual or the brochure that is available with the product is protected by copyright. On the right hand side, we see a compact display, a CD player. So similarly, you can see the 3D shape. This can be protected by a design. Then the various components and the mechanistic aspects, the technical aspects, they can be protected under patents. The brand name that is written here in this manner, that is protected by trademark. And the music that can be played in this player is protected by copyrights. Now I'll move on to patents. I'm coming back to the initial statement of invention, innovation, patents, and commercialization. So basically, you must be wondering, what is the difference between invention and innovation? There is a fine line of division in it. Invention is anything that is different from what is already there. It need not be very drastic. It can be a minor one, a trivial one. So then trivial ones are called inventions. Whereas if there is something significant that is done, and there is something significantly better than what is already there, then that is innovation. And these inventions or innovations, rather I would say innovations, can be protected by patents and then commercialized. What we see, in reality, what we see is we have a lot of inventions. Out of this, only a small portion of it is innovative. They are innovations. Even out of these innovations, only some have been patented. There are several patents, but not all patents are innovative. They could be minor incremental or incremental modifications which have been made. You may get a patent, but not sure whether you can actually commercially exploit those, because there could be some overlap, or there could be some prior art or something individually which stops you from commercializing your technology. But these innovations are the ones which we can. And only a few of these innovations are actually protected by patents. Why is this so? Maybe some people were like us, who didn't realize the value of the inventions, or did not know the importance of filing a patent. Or also, unfortunately, there are some people or companies who cannot afford it. Yes, patenting is definitely a little costly affair. But when you look at it from the bigger picture, what is it? In the long run, it is like an initial investment that you make for a long-term revenue generation. So always it is essential to look at it that way. In fact, there are several institutions, financial institutions such as the banking services, who actually mortgage. You can mortgage your patent, and you can take money, loan, and you can develop your activities. So it can also be used for that purpose, apart from your technological growth. Okay, so that is how you can do. Unfortunately, the small portion has to increase. That is what we would all want and wish. Now I have been saying patents. We have all been saying patents, patents, patents. What is patent? A patent is nothing but a techno-legal document. Why do we call it document, techno-legal document? Because techno-legal document, because there are lots of technical aspects associated with it. The invention itself has a lot of technical aspects. Then why are we calling it legal document? Because it can also help you seek protection legally. If someone, you can license out, if you're licensing it out, then there is a legal aspect to it. Suppose someone is infringing your invention, then you have got a patent. Once you have acquired a patent, then you can protect your rights. If someone is using your technology which is protected by an active patent without seeking license or without seeking permission, then you can always sue them for infringement. So there is a legal angle attached to it. So that is why it is called the techno-legal document. A patent is nothing but a monopoly right granted for an invention by the government to the inventor or the assignee. When we say assignee, it's the applicant, the company. For how long? It's for a period of 20 years from the date of filing. But in certain cases, for unforeseen delays from the patent office, or sometimes, especially in the area of pharma, there are some delays due to some trials, approvals, etc. So to ensure that the inventor does not lose out on the protection period, there is an extension provided by the patent offices. It can be for a maximum of 5 years. And the patent rights are territorial in nature. Territorial in nature means, suppose you want protection in India, you have to file in India. If you feel the technology has potential in US, you have to file a US patent. If you want to file in Europe, you have to. So everywhere. So you may file in multiple countries. It may be once it is granted in all these countries, you may want to maintain in certain countries or do away with in certain countries. They have nothing to do. If it is granted in one country, it need not necessarily be granted in another country, because there is a variation in the laws. Their view is different. The way they would view and evaluate the patentability of the technology is different. So it can vary. So these are all territorial in nature. Then what is the importance of innovation? Why do we have to actually do it? Why do companies have to innovate at all? Well, we have to innovate. If you have a product and you sit upon it, you keep on marketing the same product, then there could be that the customer will get bored. They want something new, or with changing dynamics of the society and needs, always there is a need for newer and better products. So it is essential for us to keep on innovating constantly, to keep in touch with what is required and develop products. But it's not sufficient to develop products, but who hits the button first is the winner. So always at pace, whoever nurtures early is the person who benefits the most. The early bird catches the worm. So it is essential for them to keep abreast. And constantly they have to come up with newer and better products. So that way what happens? They can better their corporate position. They can up the corporate position, then they can increase the market value, and always there is a faster growth. So through innovation, companies always have to stay abreast and keep innovating and developing new products. Now, when we say primary types of innovation, then what happens? There are different types of innovation. What do we mean by different types of innovation? Incremental. When we say incremental, then it's just that, you have small minor improvements. You have very small minor improvements to existing product or existing technology. Either you are adding a few small elements or you are removing something to provide a product. Then that is incremental. Then coming to disruptive. What do we mean by disruptive innovation? Something different, drastic change. There is a totally different change. So what happens? They are applying a new technology or process to an already existing market. For instance, we have the iPhones, but before the Apple iPhone came into picture, there were these mobile phones where you have the keypads, the buttons, the scroll keys, etc. But now what do we have? A totally different system. So that is a typical example of disruptive technology or innovation. Then when it comes to architectural uh, innovation, then what we do here is, you're employing your already existing skills and the overall technology that is known. You have it for a certain market, but you are trying to apply it to a totally different market, to new customers. You're trying to cater to the need of new customers. One typical example or a small example from our day-to-day life. Earlier, you must have heard about memory foams. Memory foams have been extensively used for patient tables or sports goods, like you have the cyclist who wears the knee guards where a foam is used. Their memory foams are being extensively used in surgical process for the beds, but and various other aspects. You have this memory foams. Now, what about our mattresses and pillows? The earlier mattresses or the conventional mattresses or pillows, after they used for a certain period, they may be initially hard or even if they are soft, after a period they change the shape. And what happens? We end up with pain in the neck or back, leading to discomfort. So now they have started using this memory foam to this particular market, to a consumer area market. There to mattresses and the pillows, when they started using, what happens? Shape memory pillows. So when you sleep, it provides you, takes the shape of your body. In the process, your body is properly rested and provides comfort. So that is architectural innovation. Now, coming to radical innovation. Well, a typical example is the telecommunications. When we were all very young, we had the typical telephones where you have to dial, turn around and all that, wireless telephones or the cordless but the bulky ones. There was telecommunication. There were so many other means of telecommunication. But now we have smartphones. It's a total revolution. So this type of innovation is a radical innovation. Now, the major question is, should innovation be from within the organization or a company? Is it always necessary that innovation should be from within the organization? Well, let us see how it is. In the earlier scenario, this was all closed R&D labs. Typically, you have Bell Labs, Xerox, they had their own technologies. It was all in-house. So what happens in that scenario? The expertise is just from within the organization. And it is limited to that. And if they have to seek external expertise, they have to hire them. Otherwise, there was no way they could. Also, the venture capital, as an individual, if you approach any institute for investment, it will be a single channel and there wouldn't be any external funding sources. Also, startups were not well funded because where is the guarantee that they would repay? So, funding was also a question. And where was a picture where universities at all existed? Did they? No. But now there has been a very drastic shift in the recent years. That is, the open innovation has been taking place, wherein they're collaborating with each other. And a very good example is Procter and Gamble Connect and Develop. They collaborate with universities, they collaborate with startups, they acquire companies, they collaborate with other major companies. So these are different ways that they have been collaborating. So what happens? The technology expertise is not from just within their organization, but from different sources. For a single project, there will be multiple aspects. Even if you take a typical computer mouse, laptop mouse, see, material related expertise, some people would have. The structural design aspects, the structural aspects, a different person will have a different expertise, functionality, etc. So, different expertises coming together in the development of a single project. So, there is enhanced technology cross flow. And also, what happens when you have multiple channels, there is always more opportunity. There is always more opportunity for more capital to flow in, and also speed and or expedite your invention from your desk to the market. So this is an excellent approach that all companies of late have been, most companies at least I would say, except for a few conventional companies, most companies are always looking at this. And in this scenario, definitely universities are also playing a major role because they have the expertise, they have the knowledge, they have the minds, young minds, experts in that domain, subject experts, etc. Now that is being leveraged by big corporates. So why do they collaborate at all? Because always they can strategize. One, knowledge, just as I've been saying, knowledge they have been taking from different sources. Two, suppose I was situated in India. I'm collaborating with someone in the US and with a third person in the Asian, other Asian countries and someone else in Europe. Now my network is expanded. So when this network is expanded, definitely your market is also broadened. The opportunities widen. That is very important for a faster and wider growth. Now, there could be different approaches, just as I mentioned. If you can afford, you can acquire the company. If you cannot, you can always collaborate in a win-win situation, have agreements in place, and you can always collaborate with others to reach the market faster and deeper. A typical example is the current scenario. Now, everywhere across the globe, only one thing that everybody is primarily looking at is how to beat COVID. So, can they afford to do it singly if they have to hit the market early and fast? No. So they're collaborating with other giants, two pharma giants coming together, or a pharma giant coming with a manufacturing facility giant or manufacturing capabilities company so that they can quickly manufacture to the extent that is possible. Always, okay, developing, finding, or inventing a technology, the vaccine is a different part. At the bench scale, it's okay. But when you have to scale it, there will be a lot of challenges that one has to face. So a company which has the capability to quickly overcome these challenges and produce at such large scales is an achievement. So all this is done through collaboration. And this type of a culture is built in the path of growth. So the route to higher productivity through innovation. is that a company introduces business and technology innovations so that they can improve their operations, they can deliver new and more higher value added products and services. So not only that, they are diffused across the sector by using best practices of their collaborators, and they can quickly scale up to the requirement of the hour. Now, how does this open innovation channel work? They're using a combination of their internal resources plus external resources, and then they are able to meet the customer needs. So how do they do it? They can either sponsor the R&D, they can form consortia, technical consortia, a group of universities or companies. Or sometimes, in fact, several times when we work on various projects, we see that a few universities, they combine together, form a consortium, develop technologies, and then they sell these technologies to bigger companies. Or sometimes they come up with spin-offs, technology spin-offs. It's not just big companies coming up with smaller spin-offs. It can be universities which have spin-offs. And these spin-offs are responsible for the marketing aspect, the commercialization aspect. Then another way is your service providers. There are service providers like Article 1, Innocentive 1, Innocentive Inc. What they do, they come up with challenges, they gather ideas, they collaborate, they help people collaborate with each other, and in the process, they can come up with better technologies and products. And also, of course, licensing, just as I mentioned. Then, collaboration, according to me, is a big must if one has to develop a new and better supply system. Now, on the left-hand side, I have put in a few aspects like universities, contract researchers, CDMO, government labs, venture companies, industrial partners, all of them come together. When they come together, what happens? It is a conglomerate of people and a combined facility for manufacturing. Manufacturing combined facility, one can be physical facilities, two from the technical aspect. So what is the outcome of that? When multiple brains, when we think singly, individually, we can think only in certain direction. It will be limited. But when multiple people think, sit together, brainstorm, definitely more ideas and better ideas come, culminating into the generation or production of new products, processes, green power, materials, novel energy, renewables, solutions. Everything is a solution to a problem. The problem may be small or big. Irrespective of that, we can do that. So here's a quick survey slide, quite old one, but no, not a very recent one. But you can see how it has been increasing with respect to partnerships. Some examples, open innovation examples. I mentioned earlier that the Procter & Gamble Connect and Develop program. Swiffer Sweeper is one such quick example wherein they have partnered with IDEO. They worked together with IDEO to come up with this better product. It's not that we did not have a sweeping device, but it was something different, had advanced features and capabilities and convenience. Another example is Caterpillar. It has a very smart mining ecosystem. It has different types of collaboration. Now you can see over here. They were partnering with others. They wanted to strengthen their IoT platform technology. So they partnered with others. They made investments to expand the platform automation, optimization, analytics capabilities. They entered into several joint ventures, and they also looked at mergers and acquisitions. They merged with a few companies, they acquired a few companies to achieve their success. Now, this is another example. You see, Verb is formed through a collaboration between Verily Life Science and Ethicon. So, Verily Life Science, its parent company was Google, Alphabet of Google. Ethicon, it's a major name in the area of surgery. They have a lot of devices, lots of patents. to their credit. They formed verb. What was the aim of verb? They wanted to integrate these surgical devices with capabilities such as robotic aspects, machine learning tools, and best in class. So it's a collaboration with others, and then they form verb, which is actually catering to these developments. So basically, if you look at it, why would they want to go? If you go for the conventional surgeries, a bigger incision has to be made. When a bigger incision is made, a lot of trauma, more time-taking, time-taking process, etc. Later on, the minimally invasive, the laparoscopes had come, wherein it could reach the organs of target sites, which was physically hindering or difficult. And you definitely understand, that operations, surgical procedures take a lot of time and it's very tiring for them. So then they thought, for precision, why not we introduce robotics? And to introduce robotics and to ensure that it has high precision and meets or caters to the needs of the surgical procedures, then this is the area where they were trying to strengthen themselves. Now I'm going into the depth of patent analytics and how it can be leveraged. When we say patent analytics, analysis is nothing but fine slicing information. So patent informatics. We have different types of information that is associated or tagged with patents. You have bibliographic information. When I say bibliographic information, it means what is it a patent about? There is a number that is associated with it. Once you file for a patent, the number is provided, the application date, priority date, publication date. Then you know who is the applicant and what is the classification. Then you know what are the classification codes that are attached, and then which countries. When you look at the family members, which countries. So how does it help by knowing that? And then all such information, it actually forms, even the citations are present as part of the bibliographic information. Then you have the technology or invention related information. That is specification and classification codes. When we say, before I go to specification, I'll speak about classification codes. If we were to look for a book related to DNA or a viral manufacture procedure, if I walked into a library, how would I be able to get the book or a journal related to that? Indexing is done. If there is proper indexing, we can directly look up, walk directly to that track, pick the book or the journal where you could find that information. Similarly, such coding is done, classification is done to the patents. So based on the classification code, you would know that a particular technology belongs to a certain technological area or domain. It makes life simpler for us to retrieve information when we are going through the analytics. Then coming to the specification, in this specification, we have technical aspects like the title, which indicates what the invention is about, then the technical field of invention, that is, to which field does this invention belong to, then the background or the prior art, that is the existing prior art, closest prior art, then object of the invention. Why was this invention at all come up with? Then summary of the invention, the drawings that are associated, the description, then detailed description of the invention and the best mode of executing the invention. Then you have the claims and abstract. Claims are the myths and boundaries of an invention. That is, whatever you claim is what will fetch you protection and not what is there in the description. Description is just an extension or extended explanation of your claims. So when you are going for a patent filing, you have to remember that all the key aspects, be it the component aspect, the structural aspects, or the functional aspects, or the mechanistic aspects, are properly and appropriately presented in the claims. That is our technology. Now, next you have citation related. What do you mean by citations? Citations are nothing but, when you're preparing a journal publication article, then what do? you definitely put in some references. Even when you're preparing your thesis, you put in some references, and these references are nothing but citations. Suppose I have a patent, I'm citing someone's patent or journal article or book reference, then that is backward citation, right? Suppose someone is citing my patent, then that is forward citation. So why would we want to look at citations? Who would cite at all? Only a person working in that area or allied area would cite your reference. So it is an indicator as to who are working in this area or who can use this technology. Then comes patent family information. What is a patent family? So for a single invention, you keep filing in multiple countries. So when you file in multiple countries, it is territorial. So you have to file in those countries. And where will you file? Where there is market potential. Otherwise, why would you pump money in a country where there is no potential? Right? So by looking at that, when you know that someone has filed a patent for a certain technology in a certain country, it means that it is a country of high potential. So you don't have to go and do market survey research to see if your technology will have potential or not. By looking at this information, you will know which are the markets where there is potential for your technology. Then comes the prosecution or legal information. This is also very, very critical. One can see, suppose you want to use a technological aspect that is protected by a patent. When I say protected, there is a patent which has been granted. You get rights for 20 years provided you keep paying the maintenance fee. Sometimes companies, they maintain for a certain period. After that, they may not want to go ahead with it because it may have become obsolete or may have become less relevant to the context, or the market may have changed. So in that case, it will become, they may not pay the maintenance fee, which means it is in the open domain. It becomes inactive. So if it is inactive, then you're free to use without seeking license. That is one thing. Someone has applied for a patent but may not have got a patent. The patent office may not have granted, they would have rejected, or they themselves may have withdrawn, or it may have been invalidated, which means these are all different scenarios where they are inactive. Or also another scenario where they may have lived the entire patent lifetime, that is 20 years, and then it falls in the public domain and you're free to use it. So these are ways you can look for patents which one can use once they are expired. But suppose something is active and then there is an aspect which is overlapping, then, and without seeking permission or without paying, you cannot use it. But you see that, when you're about to launch a product, FTO, freedom to operate search, or a right to use study has to be done without pay. And where do we have to do? In the country, like, you have to patents for, suppose my interest is to market a product in India, US and Europe, then I will only look at patents that have been filed in these three countries, see if these are still active. And if they are active, then I will read and dwell deep into the intricacies of these patents to see if there are any patents which will be a hurdle for me for using the technological aspects that are captured in that without seeking license. Sometimes it can be that, okay, you approach them, but they may not want to license it out. Then what do? There is one way, that is, you can try and invalidate. There are various ways of invalidating. There is various grounds for invalidating an already granted patent. But one technological way of looking at it is if you can dig a prior art that is there prior to the date of filing the patent application, which is blocking your path, then we can always invalidate. We can file, submit the request to the patent office, they will review, and then if found to be correct, then it will be invalidated, revoked and nullified. Then you're free to use it without having to pay a penny to that patent holder. There have been instances. I can recall one particular instance. When the medical device company had approached us with a particular patent related to a certain surgical device. So we tried to look for all potential ways. We could look at patents, we looked at brochures, we looked at the journal articles, book, news articles, news items, anywhere, everywhere we looked. in the medical domain, we didn't get anything, unfortunately. Then what we did, we expanded our search approach. We moved on to other domains where there was a potential for that particular technological aspect to be applied. And finally, we found a critical reference in the automobile area. To a general person or a normal person, we wouldn't even think that that particular aspect which you're using in a medical device would have been used in an automobile industry. We dug that reference and provided to the client, and they could successfully invalidate the patent and use without having to pay anything to them. So this is one example. Another example that comes to my mind and which I often cite on different platforms is, because freedom to operate is very critical. If one does not pay attention to this and they go ahead without conducting a proper freedom to operate study, they are likely to close shop. Many companies had to close shop, shut down because of the infringement suits that they got entangled in, the payment, the defamation, everything gone. So it's always important to do that. So this particular instance that I'm citing right now is a particular device which had multiple components, probably about 25 to 30 aspects, small, big, everything. There were multiple aspects. And then we conducted the FTO for each of these elements, and everything was clear except for one small component which was used much within the device. It has a certain functionality and critical, but present within the device, which to the general eye would not be visible. So they had an option of either seeking license, invalidating, or stopping from marketing. So then what happened is, what they thought, you have to weigh your pros and cons. Is it worth seeking license and going ahead with the product, or should they stop it? They felt that they should take a license and go ahead with the device because the device was a high potential device. Well, certain mindsets will be there where they will think, well, this component is within the device. Who will see? Never ever think in that direction, because a person holding a patent for a technology would always have their eyes and ears open and would procure their competitors' devices, products, or processes, do reverse engineering to see if anyone is infringing, and then file infringement suits. So this is a word of caution, and it is essential that one goes for patent studies much before they get entangled in any of these aspects. This is a quick look at a patent document. I'm not sure how many of you got an opportunity to take a look at a patent document. So this is the front page of a patent document, which has a title, the applicant's name, related filing details, classification codes, citations, abstract, then front page drawing. Then this is about the technical specifications, then claims, etc. Now, why does patent information study have to be done at all? One, you would know the state of the art, the prior art, you can know that. Another thing is to primarily you can avoid duplication of R&D work. It does happen. Many of us may happen to think alike. And so you can see what is already there. You can understand what are the problems that are there, disclosed in those patents, what are the solutions offered by others, and then you can take it off from there. That way, what happens? You're saving time, money, and also you can try and expedite your future work. It may give a direction. You may be thinking that, well, let me work in this direction. But when you go through the study, when you have the report, when you do this analytics study, patent analysis, then probably you may get better ideas, or you may think that your initial idea may not be good enough or may need modification. It will give you a direction. And then you can accordingly make a shift and come up with a good technology. And also it is essential for companies to always keep monitoring how or in which direction the technology is heading. Then you can also look at what are the potential licensing opportunities or commercialization opportunities. Then what other business opportunities? By looking at the different family filings, you can also know where you can, which countries you can, what are the new markets that you can tap. And also, like I said, the memory foam, it is a different market area. So that is a new business the opportunity. So this way you can always keep an eye by these studies. And definitely, a very important critical thing is you can avoid infringement suits by having the freedom to operate study. Well, when you're coming up, you have an invention and you're about to come up with production, initiate your production, one will have to do the FTO study. And also just before entering the launching in the market also, you have to ensure once again that there is nothing that you're going to infringe. And also what happens if you have this sort of a study in place, it will help you to avoid copying others' technologies or your competitors from entering the market of interest to you. So how we actually view this information is everything, any invention, according to us, is that it is a solution addressing a problem, small or big. So it defines, first we need to define the problem. Based on the problem, and we look at the various solutions. How do? We conduct searches for patents in different databases. Well, many of them may not have access to paid databases. They may be using free databases offered by the patent officers, but unfortunately, those are tedious, cumbersome, lack several features, not comprehensive. Whereas the paid databases, they are much more comprehensive. They may cost a lot, but at least you'll have a better report and a proper report, a much more comprehensive and thorough report. So that is where we have access to several databases, and day in and day out we check and search for technologies in which we are working on. Then we read through the information. Experts, domain experts like us, highly qualified people, subject people, they read through each of the patent documents. They fine slice the information that is there. When you read a patent, because it has techno-legal language, may or may not be easy to understand. And also, how many patents can one read if a person is not habituated or not in this line? We develop a habit of reading several hundreds of patents per day. And we know where to look for what information. So it is very important. This sort of a study is very important. Then after we read, we find slides, we interpret appropriately and present reports. On the right hand side, I have quickly presented the different types of patent analytics that we generally do. The state of the state of the art and landscape searches, prior art problem solutions, and also white space. What are the white spaces? Why hasn't someone worked in this particular area? Is it because there is a problem which they are unable to address, or no one has thought about it? And if you feel that you can try and work on this area, great. Then SEO analysis, this is something that would help someone to actually assess if they can pump in money. There was one Fortune 50 company which approached us asking to do a patent study and let them know if they can invest in a certain business area, which means several millions of dollars are being utilized for it, for that particular business division. Then based on our study, we thought that it was already saturated, and though we couldn't really comprehend that there would be high potential. But at the same time, we weren't sure that that would be well taken by them. So we gave a report with all the findings. But then they pushed us against a wall. They asked us, if you were to invest, would you invest? Yes or no? Well, then we thought, okay, if they want to go by our decision, then they will go, else they may want to make their own judgment. So what we did, we said, we feel that it is not right or it may not be correct to enter into this particular business vertical because 1, 2, 3, 4, 5. This way, we, based on our study, we provided the aspects or grounds or based on which they may consider not investing or entering in that particular business vertical. And yes, They really understood and they were appreciative. They did not invest in that business vertical and invested that money into some other business. So that is the extent to which patent analytics can play a role. Then by knowing what your competitors are doing, you can. Then you have novelty patentability assessments, freedom to practice, invalidation, claim charting, etc. Then then linking patents and products. When you go to the market, you see a lot of products, but some of them they say patent protected, etc. Or provide a patent name. But does everyone do that? No, they don't do that. Then how would you know? Competitors, as laypersons, we may not be interested, but competitors, what do? They'll lift those products, they look at the ingredients that are there in the products, then they come to us, then we look at the patents, we try and link them, match them. Well, this product is probably protected by these patents, etc. So it is very critical for them to know all that. And also, there are clients for whom we work on a weekly basis, regularly, weekly, bi-weekly, quarterly, monthly, whatever, depending on the density of the technology domain, as to what are the patents that are being filed or granted across the globe in that particular technology area. So they're keeping themselves abreast, noted, laying down everything that is coming out so that they can accordingly modify their research direction or they can further strengthen their direction. This is a cycle very quickly, like from ideation to product realization. At different stages, different studies are done and accordingly achieved. So it is important for us to evaluate the patent information to understand and determine the IP and commercial trends. When you look at the patents individually, it is not possible. Only when we we study several patents and then analyze the information, present them, look at the trends, technological trends, bibliographic trends, then you can see which direction something is headed. You can understand the white spaces. You can look at the technological advances that are taking place and what are the solutions or what are the problems, what are the research activities taking place, licensing opportunities, commercialization plans can be made on this, and who they can collaborate with, who they can partner with. Actually, one good approach for universities, people from universities is, well, you must be wondering, how can we enter into a collaboration or push for a collaboration with big companies? One, if you have contacts, fine. But the primary thing and a very good thing would be if you have come up with a good invention, go ahead, file a patent, and then you will be seen that visibility is there. For one client, we keep working on patent watches, patent alerts regularly. This particular client suddenly out of the blue comes and says, look, can you please monitor the patents coming from so and so company? That company had come up in our report. And why are they asking? Because the company is having a technology that is of high interest to them. So they would like to know what are the other technologies or patents coming from this company. So this is a very good example of keeping track of what is happening and accordingly moving forward. Well, this is where I have come. In a nutshell, I have presented how patent analytics can be utilized to the advantage of companies or individuals. I have presented. I would be glad to explain further if anybody has any questions. But one strong statement that comes to my mind is a statement made by Leslie CEO, Andy Conner. He said that we expect to work closely with pharma, biotech, medical devices, and diagnostic companies, patient advocacy groups, and academic institutions in different ways for a long time to come. So this message is always very clear across the companies. They're always constantly looking for collaboration and constantly trying to do something here. Just recently, there was a client who approached us to see identify companies with whom startups, research institutes also, with whom they can actually partner, collaborate to develop technologies. That was one thing. Then they also wanted to look at companies which had manufacturing facilities or they had manufacturing technologies which could cater to addressing the challenges that are met in the manufacturing industry. It's not just one or two isolated cases, but this is a voice that is getting louder and louder as we have been working for several years in this domain. Now, I would like to uh, end my presentation and the floor is open for any questions that you may have.
Yeah, ma'am. Um, Thank you very much for your wonderful presentation, which actually was a beautiful journey from an academic to a visionary of the world of patents. And the way in which you have presented your ideas systematically, that was quite inspiring for every listener. Now we have the Q and A session, and we have two discussants with us. Uh, the first discussant we have Rukan. He's basically a qualified plastic surgeon with international training and accreditation. Currently, he's completely into research, and he is the CEO and founder director of Zoom Helen Healthcare Private Limited, a company actively involved in research and innovation in human health activities. May I welcome Dr. Prashant Worki as our first discussant.
I'm not sure whether you can hear me.
Yeah, sure. Okay, please carry on.
I'm actually in a car and I have to pardon me that I had received this on short notice. I could not avoid this trip. In fact, it is something related to a patent. Very quickly, madam, I have three questions. How do I speed up a patent just on the basis that it is a life-saving technology I have discovered? Is there any way for that?
Like you would like to license the technology that is there in your patent, and how do you approach? Did I get you right?
No, madam.
Huh.
We have
Yeah, what?
discovered, for example,
Huh.
a cure for COVID. But before putting it to the market, I need to get a patent in an urgency. How do I speed up the process to get a patent?
There is a procedure in the patent prosecution procedure. In the process, it's a patenting process. We will have to pay extra amount. Always there is a procedure wherein you file for a patent, then it gets published. It is examined by the patent office, the controller. Then based on that, further prosecution is taken place. So if you want it to done early, then the best way would be to pay additional fee, request for early publication, and also request for early examination of your patent application. There have been instances wherein it is published before the actual time. Normally, it takes about 18 months for a patent to be published. So, by paying extra money and requesting the patent office, it can be published early. And also, you have to file the request for examination immediately with request for expedition. There you have to pay more money. Once you do that, it is done on a fast track and you can get it early. If the patent office is convinced that you can be getting a patent, it has the potential of getting a patent, it meets the criteria of patentability, it is novel, has inventive step, utility value, and also meets the other patentability aspects framed under the Patent Act.
My second question, madam, because we work a lot in biotechnology,
Okay.
when we have an idea, what about patenting it and getting a patent before we actually do a clinical trial? Is it possible, or does the patent office ask for the clinical trials?
No, if it is in the biotechnology area, you can go ahead and file for a patent. And whenever you are filing for a patent, if it is a pharma drug, the procedure is different. There you can do it parallelly. You can file for a patent. First, always innovate, file a patent first. Parallelly, you can take it to other activities. So, especially in the biotechnology area, once your
My question
invention is
was,
ready,
I
file
already
a patent.
applied for the patent. Will the patent be granted only after the clinical trial?
If something that is if it is a pharma drug related one,
Yeah.
then some clinical trials, FDA approvals, etc., have to be done over there. And then once you get this approvals, then it is granted. And there are some procedural issues associated with it. All those have to be met. Only after that, the grant can be done. You can be launching it. You have to get the patent. You have to also have the approvals. Then only you can launch your product. But
I
if it
have
is
one
just
last
a
question.
biotechnological, I'm sorry, let me just explain a little more.
Sure.
But if it is a biotechnology process that you have, for instance, you can go ahead, file a patent, and while filing a patent, you will also have to seek permission from NBA, like Biodiversity Act. You have to seek permission from them and submit it to the patent office before a patent is granted. That is a rule in India. Yes, please. You can move on to your next question.
Yeah, just for time's sake, I'll be very brief. I want to know, can I patent a service? I have a service that is made on an algorithm for a patient care. Can I patent
Hmm.
it?
Actually, algorithms as such, they are not patentable. But then what happens is, if you have a device in which an algorithm is embedded, the device along with the algorithm can be
Can
patentable.
be.
But algorithm as such per se is not patentable in India because
Yeah.
all
So that's
software,
why.
etc., protected by copyrights in India.
So that's a very specific, madam. The device is a foreign device which has got a patent, but the
Hmm.
process is mine to manage the patient. So that process with the device can be another patent.
No, it's like this. If you're looking for a device separately and the way it is functioning, no. Because the device plus the functionality, when you're speaking about a device, you'll be speaking about the components, you'll be speaking about not only the structural aspects, but the functionality and how it is executed, mechanistic aspects. So it is as a whole. So you can have only one pattern. But suppose you have a product and you have a process of getting it. If these two are novel, and then you can file one as for the product and another patent for a process. But if you're speaking about a device that has an algorithm or something or some means by which this device is functioning, everything goes in a single patent. It depends on how you can draft the claims. It is case to case. We will
Yes,
have to see
sure.
and accordingly draft the patent.
My last question is, I'm not sure whether it will interest the others. Can you patent a mobile app,
Can you patent it?
mobile application,
No,
a mobile app,
application.
a mobile phone application?
Mobile application. No, mobile application as such is not patentable in India because that will fall under copyright. So what you can do, suppose mobile application is integrated with a device, then say for instance you are having a fitness device wherein
Right.
which can be, and you have an app through which you can download in
It's
your
taking some data.
mobile,
Right.
and that device is integrated with this app, and your invention is describing about this app plus this process of using this device, integration with this app, and achieving
Then you
the
can.
end result of monitoring, then you can patent. But it is
Sure.
just an app on the mobile. It cannot be patented in India.
Sure. From a college perspective, my last question. Usually, we engage people from St. Thomas College to work in our team. Now, when I
Uh,
file a patent, is it justified to keep them outside the patent? I have paid them to work for me. For my idea, I pay students to work.
You
So
are
how
using
do we take
students
care
of
of that?
that college. You are not, see, normally I'll tell you, if you are outside the college and they are students of the college and you are trying to use that, basically that would become unethical first means. Then if they are part of your invention, okay, they have not developed the technology using the university's resources or on the premises of the university, and they are working with you and they have developed something, then they can always get a patent, they can file a patent with you, and you will have to have an agreement in place as to what monetary benefit they can get out of it. And
It's
suppose they work
it's a
with the university, suppose they work within, they are working, a lot of universities, they have the research labs also there, they do a lot of research takes place, something is developed over there, and then that is taken out without the permission
that
of the university, then it is not
that's
allowable.
no. We are in the opposite space. The idea is mine. Everything is mine, documented. I get students to work on my idea. That's all. They do an internship or something.
Okay, okay, then they have no stake in it. If the idea is yours,
Sure.
you have total stakes. They would not have any stake to it.
Yeah, and we usually do a non-disclosure agreement and a agreement of
Yes, exactly.
confidentiality before they
Yes,
engage.
yes, exactly. Even when our clients approach us, we first insist they sign an NDA. Though we do understand confidentiality requirements, we do not disclose the project details. We do not share information even within the organization. It is shared only on a need-to-know basis. We have internally very robust confidentiality agreements in place. Despite that, we in many clients, several clients, some of the smaller clients, they may not be aware of it also. We insist they sign an NDA with us and then only disclose their invention to with us and then take up work so that there will not be any scope for any misgivings. And
Yeah, my
so you
last
have an NDA in place, you get them to work, and then you can be the sole applicant. You can pay for whatever services, like whatever work they're doing, you pay them. That is it.
yeah, my last one, and it will take a minute for this funny anecdote. So we had a student who worked like this on a project and put the project on his CV for application for a job.
Okay.
When the NDA is signed, the property is confidential to us. He has written in his CV, he has worked in this
Hmm.
project. And
Ah,
the funniest part in this anecdote is that one of our
hmm.
team members interviewed him later, a year later, for him having displayed this, and he repeats the entire thing which is in confidentiality he has disclosed. So,
That
what
is,
legal action can I take for that? Is there any
you
legal
can.
action I can take?
Yes, yes. If there is a breach or with respect to the agreement, if there is a breach of conduct, then you can always approach the courts for breach of conduct and accordingly. But also then that if they want to, when they work for internship, they're working with you. Maybe there is only a certain aspect without actually revealing the details they can probably present in the thesis or dissertation, that too with your consent. Without your consent, if they are doing it, then you can always take a legal action if they're breaching. It depends on what is there in the agreement.
Yeah. Thank you very much. I think the rest of the panelists have their time. Thank you very much.
My pleasure.
Uh, Thank you, Dr. Prashant Varki, for your wonderful participation. And it was immensely interesting that a practitioner supplements to the discussion which was going on. That was really, really interesting and illuminating.
Thank you.
Thank you, Dr. Prashant Varki, for joining us. And now we have our second discussant, Dr. Reggie K. Joseph. He's an academic. He's an associate professor in the Institute of Studies in Industrial Development, New Delhi. He will join us soon to discuss with Dr. Lakshmi Shanti.
Okay.
Dr. Reggie K. Joseph, am I audible to you? Maybe this is a small connection problem. Let's wait for a half minute so that Dr. Reggie can join us.
Yeah. Well, I will just add one thing. While we are waiting for him, probably I can share one experience,
Sure.
There was an instance, when a woman entrepreneur approached us. She approached us. Uh, she approached us for a typical case. This is an unfortunate scenario. She had done her doctorate with a certain university, and after completion of her doctorate, she had set up a unit, and she was very successful. And in good faith, there were discussions between her guide, research guide, and herself. And he used to always ask her what work she was doing, what was the progress, what are the results. In good faith, she has been disclosing everything. And then one day, unfortunately, she receives a infringement suit notice from saying that this professor or the guide had a patent related to the technology and that she has to cough up money. Then she came to us. Then one suggestion that I gave her was, our first question I asked was, do you maintain lab notebooks? It is very important to maintain lab notebooks. She said, yes. I asked her, who has access to the lab notebooks? These lab notebooks are in the office, at her office, and at present it is in a common area. Then immediately I told her, well, fine. Immediately go back to your office, take the lab notebooks, keep it in your personal custody. Where? Because in the lab notebooks, details such as the date, what are the various experimental activities taken place, and what were the findings, everything are being noted in that particular notebook. So I told her, then use this in your defense and corner the guide. Unfortunate scenario that the person who, we always say Acharya Devo Guru. We treat them, gurus, we treat them in a high pedestal. Unfortunate that person had stooped to such a low level, and that too to a person, he has done harm to a person who trusted him so much. And then she had followed this particular aspect and it went to the court and she had used lab notebook. So this is a suggestion to all of you. If you are not having this practice in place, please do maintain your lab notebooks. It need not be chemistry or chemical reactions, any experiment or any technological activities that is being done. Have a date put to it, enter details, have a counter signature. We have this practice at the ICT, CSIR, we had this practice. Even a sample that is submitted for characterization, we would provide the sample name and the date when the sample was provided so that it can always be corroborated. It helps us in the long run. So if this practice is not in place, please do implement this immediately and wherever you go. Students, definitely, I think this will be a learning for you, and even professors also. I think, you can also use this to ensure that the technology that is there within the organization, whatever is developed on the university premises is within you. Yes, sir. Is Dr. Reggie on?
Dr. Reggie, am I audible to you? Ma'am, I believe there is a very serious connection problem with him. He's not able to enter this thing. So there's only a minute for any other participants. Any of the participants need to ask a question to Dr. Lakshmi.
Yes, any questions? They can type their question and I can quickly answer. I think that would be better
Yes, you can.
also
Yes, yes, yes.
in the
Participants,
chat window.
participants can just type in the chat box. I don't think we have more questions. Ma'am, Dr. Lakshmi Shandhi, ma'am, and all the participants, we are just shifting to the valedictory session of this wonderful 4-session webinar. Over to Neetu.
Thank you, Biju sir. Thank you, Dr. Prashant, for being with us. Thank you, ma'am, for your enlightening session. We are extremely grateful to all the participants for your active presence. Hope audience feel the feedback from provided in the chat box. The session was the last session of our 5-day international webinar series. Hope all of you had an insight about the various aspects of IPR and it helps to improve our portfolio. We are coming to the end of our series. Dr. Joby Thomas K, the Vice Principal of St. Thomas College, Thrissur, has joined us today. He is a recipient of many awards, including Professor M. Ghani Award for the Best College Teacher, Insight Teacher Award by Indian National Science Academy in 2016, Best Teacher Award by Chemical Research. He is a great researcher, research guide, and PhD thesis adjudicator to various universities. I welcome Sir to felicitate the gathering.
Good afternoon to all. The respected resource person of the day, Dr. Lakshmi Shandhi, the chair, Dr. C.S. Biju, the Department of Computer Science, Dr. Jiju Matthew, the faculty members, Principal Dr. K.L. Joy, the organizing team, and my dear participants. At the outset, I would like to congratulate the Department of Computer Science of St. Thomas College Autonomous Thrissur for arranging a platform for the researchers and the academicians to have more light into the area intellectual property rights. The knowledge about IPR is quite essential not only for researchers but for all academicians. The intellectual property rights, needs, and awareness for industry and academia was the title of the webinar series, 5 days webinar series, and I feel that all the days were excellent, were very much beneficial for the participants, and of course, all of you have enjoyed it, get benefited from that one. At this moment, in this concluding session, I especially acknowledge all the dear resource persons for the 5 days and their excellent lectures on different topics of IPR. On behalf of St. Thomas College Autonomous, I expect their further association with this institution, especially to have more knowledge about this IPR and related subjects. Once again, I would like to thank all the research persons. Also, I thank the chairs of each day's sessions. Today, Dr. C.S. Biju was there, my colleague and very good researcher, and being the coordinator of the Research Council of St. Thomas College, Thrissur for the last 12 years. We are very much in need of having a platform like this, especially in this COVID pandemic situations. We have asked various departments to arrange a program on IPR, and that challenge was taken up by the computer science department. Therefore, I especially thank the Department of Computer Science for having accepted this appeal to arrange an intellectual property rights webinar, and they have arranged this excellently, wonderfully. I have attended many sessions and experienced their arranged hosting mannerism. Therefore, I thank the Department of Computer Science, all the staff by Dr. Jiju, and other members, the students who are behind program. Their tireless efforts made this program a great success. I thank all the computer science team at St. Thomas College for having this platform, for having more knowledge about IPR to the academic industrial people. Thank you one and all, and I thank all of you for having for inviting me to this concluding session. Thank you.
Thank you, sir. Now I call up Ms. Ravila Ravindran, Webinar Coordinator and Assistant Professor of Computer Science Department, to deliver vote of thanks.
Thank you, Nidhi. It is indeed my privilege to propose a vote of thanks on this occasion. I, on a personal note, and on behalf of the Department of Computer Science, St. Thomas College, Thrissur, express a hearty vote of thanks to all present here. I, on behalf of everyone present here, extend my gratitude to the speakers of our webinar. On the first day, we had Manju Gerard, Principal Scientist at ICAR New Delhi. She, during her talk, reiterated that there is a vital role for IPR in growing economy of developed and developing countries. According to her, building awareness and strengthening IPR can drive business growth, create employment, and spur economic development. On our second day, we had Ms. Angayar Kanni Ramaya, who is a senior lecturer, University Technology Mara, who enlightened us on how competition law complement and support IPR. The next day, we had with us Dr. Manoj P. Samuel, the Executive Director, Center of Water Resource Development and Management, Calicut, who during his lecture gave us an overview of the different types of intellectual property and even provided advice to startup companies on how to secure their intellectual property as well as protect intellectual property risk against others. Yesterday, we had Dr. Reggie K. Joseph, who is an associate professor at the Institute of Studies in Industrial Development, New Delhi, who joined us and shared his experience on the significance of innovation in business and development. Today, we had Dr. Lakshmi P. Santhi, who is a senior manager at SciTech Patent Art Services Private Limited, Hyderabad. According to her, patent analysis, it provides an overview of the innovation and it helps to track technological development. It helps in understanding the state of art technologies, the underlying problems and technical solution, thus enabling monitoring trends in technology, filing, assessing market potential, aiding in realization, commercialization of technology, identifying of potential licensing, business opportunity, and thus gaining competitive advantage. I wholeheartedly thank all the dear, respected resource persons who made this seminar and great academic exercise, which I'm sure has benefited each and everyone present here. Next, I would like to extend my thanks to Dr. Prashant Worki Amugan, who is the CEO and founder of Zoom Island Healthcare Private Limited, for his presence and interactions. His healthy involvement in our session made it livelier and more interactive. Thank you, sir, for being with us in spite of your busy schedule and commitments. I would like to thank our management, who has always endorsed academic excellence. I extend my thanks to my college management for their enormous cooperation and support showered on us. Our principal, Dr. K.L. Joy, has always encouraged and inspired us to bring the best. I take this opportunity to extend my thanks for all his support and words of encouragement. I would also like to extend my thanks to Dr. Father Anil George K., who is the IQAC coordinator, Dr. Father Martin Columbreth, Barsar and Vice Principal of our college, Dr. Joby Thomas, Vice Principal of our college, Dr. Sanal Raj, Dean of Arts, and Dr. Brito Joseph, Dean of Science, for all their support and guidance. I would also acknowledge our gratitude to Dr. Sister Alfonsa Matthew, the Vice Principal and the CPA coordinator, for their kind words and also the funding for our webinar. I also extend my gratitude to Dr. John Snudworth, the President of Institutions Innovation Council and the coordinator of Startup and Innovation Cell of our college, for all the support and contribution in the smooth running of this event. Further, we are grateful to Dr. C.S. Biju, Associate Professor in English, and Mr. Emmanuel Thomas, Assistant Professor in Economics, who had consented to chair our sessions. Next, I would like to thank all the delegates across the world who had been a part of this webinar since the past 5 days. I would extend my gratitude to Mr. Jason Saju for the technical support provided for the past 5 days. Next, I wish to thank my dear students, Ms. Neetu Krishna Singh, Ms. Asna Babu, Ms. Jomia Jojo, Mr. Jojo Anto, Ms. Anshi Anthony, Ms. Lakshmi P, Mr. Akhil James, and Mr. Alvin James for their organizational skill and dedication. Last but not the least, let me extend my sincere gratitude to Dr. Vijay Matthew, our department head and the convener of the program, and all my dear colleagues for their constant support. And I'm sure these 5 days has been fruitful to you. Hope to meet you all soon in near future with yet another topic of significance. Thank you once again.
Thank you, ma'am. Every celebration is an experience. The external fades away, but these events are like the milestone in the journey of life. Hope this academic activity will prove to your milestone in your career. This is Needu Krishna signing off from St. Thomas College, Autonomous Thrissur.